In Arizona, if someone is to be sentenced for a misdemeanor DUI, and they have also been convicted of another DUI within 7 years of the commission of this DUI, then they are subject to the much harsher sentencing provisions for second offenders. However, there are limitations on the use of other convictions to invoke the second offense sentencing provisions, and so it may very well be that even though the conviction exists, it cannot be used to invoke the second offense sentencing laws. Now, in order to invoke the second offense sentencing laws, what the prosecutor must show to the court is the following. Number one, it's the same person in both cases. The identity is the same. Secondly, in the other case, the person was either represented by an attorney or advised they had a right to be represented by an attorney and waived that right. And thirdly, that the person was found guilty of violating Arizona's DUI laws or engaged in acts in another state, which if committed in Arizona would be a violation of Arizona's DUI laws. Now, many times convictions from other states are insufficient to invoke the second offense sentencing provisions. Now, the way a court in Arizona that's going to be doing the sentencing would determine what acts the person engaged in the other state is to look at the records from that other state's court case. It simply wouldn't make sense to have the witnesses from the other state come here and have a trial on the merits of the case. I mean, that's impractical. And so the only way the Arizona Sentencing Court can make that determination is to look at the records from that other case. Now, the records from that other case, though, are not going to say what acts the person engaged in. They're only going to say that the person engaged in acts which were a violation of that state's DUI laws. And so the court in Arizona determines the acts by looking at the other state's DUI laws. And if that state's DUI laws are different from Arizona's, then that wouldn't be enough to show the person had engaged in acts which, if committed here in Arizona, would be a violation of our laws. Let me give you an example. Let's say another state made it a crime to be driving with an alcohol level of 0.05% or more, and a person was found guilty under that law. Well, that wouldn't be a violation of Arizona, because that wouldn't be an act which committed here in Arizona would be a violation of our laws, because our laws are a standard of 0.08. So such a conviction would be insufficient to invoke the sentencing provisions for second offenders. Let me give you a second example which is a little more involved. Let's say the Arizona law is, as it is, that a person is guilty of DUI if they are driving or in actual physical control of a motor vehicle while impaired to the slightest extent by alcohol or drugs. Where Arizona differs from most states is in the concept of actual physical control. Because what that means is it's not that you have to be driving to be in violation of the law, but rather in actual physical control. In Arizona, actual physical control is defined as, does the person actually pose a threat to the public by their present or imminent control of a motor vehicle while impaired? Let me say that again. Does the person actually pose a threat to the public by their present or imminent control over a motor vehicle while impaired? Now, most states only require a finding by the judge or jury that the person exercised present or imminent control over a motor vehicle. They do not require this additional element that Arizona does, that the jury or judge make a finding that the person actually posed a threat to the public. And so a conviction under another state's laws that did not have that additional requirement would not be a violation of Arizona laws and would be insufficient to show that the person had engaged in acts in another state, which if committed here would be a violation of our laws. Now, these arguments are rather technical arguments that lawyers make in court. But the important point you should have is this. If somebody is charged with DUI and it looks like they're going to be found guilty and they have another conviction for DUI, never assume that they're automatically going to be sentenced as a second offender, because it's quite possible that the conviction will be insufficient to show that, particularly if the conviction is for somewhere besides Arizona.